All right.
Dinesh, I think you accidentally disabled my access keys for the video chat data repository.
No, actually, I deleted them on purpose.
What the fuck, Dinesh?
I'm sorry, I really am.
Suck a dick.
I'm sorry, what did you say?
Nice blazer.
Incredible.
Do you think I have too much product in my hair?
Nope. I think you should use more.
Quite a turnaround for a company that wasn't exactly soaring.
Oh, it was soaring, Emily. Right into a clogged toilet, and not just like a standard clogged toilet.
Are you familiar with COPPA?
Who?
That's the Children's Online Privacy and Protection Act.
This act establishes strict guidelines to protect the privacy of younger children on the internet. You are in gross violation of this act.
51,000 estimated underage users, times an average 25.6 chat sessions per user, times $16,000.
$21 billion?
I mean, I knew Dinesh was going to fuck this all up, but honestly, this couldn't get any better.
Every sound is $16,000. Fuck!
All right, don't think about that. Just think about how to solve this massive, massive problem.
How's it going?
Good.
Well, look, I've been there, man.
Really?
But then I pulled down my pants, sat down, but instead of shit, I threw up into my pants.
Well, I was CEO for 11 days.
Okay.
I was CEO for 11.
Oop. You get the point. Ironically, the fines now, not ironically, but shockingly, the fines per COPPA violation now are as much as 40,000 per violation. So technically that 20 billion plus number could be a lot higher. I want to talk briefly about enforcement since we're on this topic, and then I'm going to come back and show another video with our friend Mark Zuckerberg at Facebook. But enforcement on for COPPA has been sparingly over the last 18 years. We've seen probably somewhere north of 25 cases, but that's very few over such a long period of time. And I think the largest fine has been somewhere in the neighborhood of 3 million, maybe 4 million, 3 million against Disney, 4 million against InMobi, which is a company here, but they actually had to pay only close to $1 million. What do you think we'll see with GDPR enforcement? I mean, the fines can be a lot more significant. What do you think we'll see with GDPR enforcement?
That's, I think, the million-dollar question in many ways, because I think the regulator really will have to make a move pretty quickly in order to establish the credibility of GDPR. And right now, everything that we hear about how the regulators are preparing for GDPR seems to indicate that they're themselves struggling to hire all of the people that they need to regulate the industry and to apply GDPR. So I'm not convinced that we're going to see a lot of action very quickly from the regulators, but I think that is to the detriment of GDPR because there's so many areas of uncertainty and everybody's waiting for some cases to start proving, exactly how GDPR and GDPR-K should be implemented.
Do you think there will be a focus on some egregious actors initially, as well as the big tech companies?
I would have thought so. I mean, I would think that the regulator ought to be focusing on the big platforms, first of all, because that's where they will have the most impact and where they can set the best examples. I don't think they will be investing a lot of resources in going after smaller companies or publishers of the sort that are in this room today, for example. That would surprise me if they went after those kinds of players.
One key difference between COPPA and GDPR, and then we'll sort of take this conversation back a little bit, because I'm assuming everyone here knows what GDPR is, as well as COPPA, but we'll take a few steps back, is that COPPA doesn't have a private right of action. So you can technically have a law firm, a plaintiff's law firm in the US, bring a lawsuit against a private company as a class action lawsuit. And the GDPR is different. Technically, under the GDPR, you could bring a private lawsuit, class action lawsuit, except that I believe the law firm bringing it or the organization bringing the lawsuit has to be a nonprofit. So what's to prevent some crafty lawyer out there starting up a nonprofit, paying himself $1 million salary a year, and bringing a bunch of lawsuits against tech companies for GDPR?
Well, I think that's already happened, hasn't it? Isn't that what Max Schrems is doing? So,
well, tell us more about that.
So, I mean, so you make a good point that, you know, under COPPA, there are no civil lawsuits. That, however, hasn't stopped law firms in the US from filing intrusion of privacy civil lawsuits against Disney, Viacom, Kiloo, and others, citing COPPA as the standard for assessing whether, you know, someone's privacy has been intruded. So we are seeing more civil litigation around COPPA in the US, and I do think that's a trend that will continue. But as you rightly point out, Shai, GDPR does allow for civil lawsuits, and what we've already seen is Max Schrems, who's a young Austrian lawyer that became quite famous at the age of, I think it was 23, a few years ago when he sued Facebook, essentially, for the way that they treat his data and challenged the European arrangements with the US on where data can be transferred. Successfully took that to court and effectively destroyed what was then called the Safe Harbor, pre-Privacy Shield. And he has now founded a nonprofit called Mind Your Own Business, I think it is, or None of Your Business, with the express purpose of suing under GDPR the big social media platforms. And in fact, on Friday, he filed 3 complaints, I think it was, against Google, Facebook, Instagram, and WhatsApp in various courts around Europe with various regulators. And so he's doing exactly that. And I do think we will see more activist activity like that.
Okay.
I mean, I think it depends on where you sit, obviously, whether that's a good thing or not. But I think if we can agree that the principles underlying GDPR are positive ones, that we do need something that's principles-based like GDPR in order to build a better internet, whether it's for kids or for adults, then, you know, I think we need to make sure that GDPR is tested right away and that it's shaped by case law as soon as possible. And if the regulators aren't going to have the resources to start filing tons of enforcement cases themselves, then we are going to rely on adjudication in the courts of private cases to give us that case law. So I do think it's a good thing, certainly from our perspective.
Well, let's assess that a little bit further. I'm waiting for this ad to run, and then I'll... The irony of Zuckerberg in his recent testimony to Congress, did anyone watch that? Get drilled by the Congress here not here, but in the US, and then later here by the regulators here, is that Zuckerberg kept getting asked, do you sell data? And his answer was, Senator, no, we do not sell data, we run ads. Is there a difference? Is there a difference? Who thinks there's a difference between selling data and running ads? Raise your hand. Who thinks there's no difference? It's the same thing. Some neutral? Well, what if the ads that you're serving is based on the data that you collect? Are you then selling data? You are? So then running ads is selling data, is it not? I don't know, something to think about, some food for thought.
I mean, when you buy an audience on Facebook by selecting the categories of person that you want to advertise against, you're essentially buying Facebook's first-party data set. It's exactly the same.
Run ads against that data set.
The only difference is that you can't take it with you.
Well, he wouldn't answer that question straightforward, but this one's even more fun.
Online privacy bill of rights. Would you support a child online privacy bill of rights for kids under 16 to guarantee that that information is not reused for any other purpose without explicit permission from the parents or the kids?
Senator, I think as a general principle, I think protecting minors and protecting their privacy is extremely important. And we do a number of things on Facebook to do that already, which I'm happy to get into.
And I appreciate. I'm talking about a law. I'm talking about a law. Would you support a law to ensure that kids under 16 have this privacy bill of rights? I had this conversation with you in your office 7 years ago about this specific subject in Palo Alto. And I think that's really what the American people want to know right now. What is the protections what are the protections that are going to be put on the books for their families, but especially for their children? Would you support a privacy bill of rights for kids where opt-in is the standard? Yes or no?
Senator, I think that that's an important principle. And
I appreciate that.
And I think we should...
Do we need a law to protect those children? That's my question to you. Do you believe we need a law to do so? Yes or no?
Senator, I'm not sure if we need a law, but I think that this is certainly a thing that deserves a lot of discussion.
I couldn't disagree with you more. We're leaving these children to the most rapacious commercial predators in the country who will exploit these children unless we absolutely have a law on the books.
Please,
and I think it is absolutely
Please give a short answer.
Senator, I look forward to having my team follow up to flesh out the details of it.
I don't think this is a
Senator
difficult
Senator
issue
Flake.
to get a correct answer to.
Thank you, Mr. Chairman. So why on earth will he not answer that question? Because it's already law. That law is on the books. But he was talking about the U.S., in the U.S. That was, well, we have COPPA, but he was talking about a newer law that would apply to those under the age of 16, not just those under the age of 13.
So obviously he doesn't want to answer the question because he doesn't want to have Facebook essentially do something that would damage its shareholder value, right? I mean, the stock price would go down if he said that, yes, I support a law that would reduce my audience. He's not going to be able to say that clearly. I do think that the discussions that are happening in the U.S. Congress at the moment, and this is, I think, the third introduction of new legislation in the last 3 months that relate to tighter data privacy controls in the U.S. Now, none of those draft bills or proposals have any chance of passing, but the point is that they are being proposed, and there is a discussion which I think points towards the general trend of the age of protection that we consider appropriate for children rising from 13 to 16. I do think that over time, with all the various initiatives that are happening in data privacy laws around the world, that's where we will end up.
Well, there is a fundamental difference between the European landscape and the US. And here, privacy is viewed as a human right, as a civil right. In the US, it's not, right? We have First Amendment protection, so it's not. And anything that would attempt to regulate anything above the age of 13 is likely to face a major constitutional uphill battle. And so that's why I'm skeptical whether anything like this could gain steam here in the US. But let's move from there and let's talk about age. Let's talk about the 13 versus 16 versus all of the ages in between across this landscape that you can see. Does it really matter? I mean, that's my question. Does it really matter? I mean, does having an age cutoff of 16 simply mean that more general audience platforms, mixed audience apps and sites are simply going to just make the age or date of birth question have a cutoff of 16 and encourage more kids to lie about their age and get onto the platform?
I mean, I do think that's, was one of the biggest problems in regulating the internet for kids that we don't really talk about enough and that the regulators don't talk about enough, which is that, do age thresholds actually work, or have our children just become so adept and wise to circumventing them that it's kind of pointless because now the platforms have absolved their legal responsibility to protect them because they've said, I only allow 16-year-olds, and yet all the under 16-year-olds are still there, but the platform no longer feels it has a responsibility to look after them. WhatsApp is probably the most extreme example of how a company can react to GDPR, where they simply just said across the board, we're just going to apply 16 and we're going to kick out all kids who are under 16. But then the way that they implemented that, of course, in such a way that it's highly unlikely a lot of under 16-year-olds admitted to being under 16 and allowed themselves to be kicked off the platform. So now you actually probably have pretty much the same number of under 16-year-olds on the platform, but WhatsApp can say they've absolved their legal responsibility. So I do think that that's a problem, and we haven't really discussed much as an industry how to solve that age verification question. And I do think if there's some technological innovation in the next 2-3 years that would really benefit, it would be to find ways of assessing and verifying the age of children on the internet and then ensuring that we can protect them whether or not they are self-declared children.
For those of you in the room, have any of you done anything around GDPR to increase the age? I mean, most of the folks here are targeting kids anyway, right? So you're not likely to adjust the age demographic or the age question because you're already targeting kids. Do we have any here that have sort of dealt with this dilemma in terms of how to figure out this sweet spot of 13 to 16? I'm seeing some nods over there. Okay, so a few. And super awesome, of course. I would actually argue that I think this is less protective, and I'll tell you why, right? If the age cutoff is 16, to me that suggests that we're just gonna have more kids lie about their age, right? And especially if we have mobile platforms like WhatsApp simply increasing the age that you need to be in order to get on the platform and use their service. And even let's look at Microsoft. Microsoft with the Xbox has done just the opposite. They haven't kicked out under 16-year-olds. What they've done is they've now expanded the requirement for getting parental consent, verifiable parental consent, to those who are also 13 to 15 years old, right? Such that if I'm 15 and I want to sign up for an Xbox account, I've got to get my parent to do a credit card purchase and give consent. Now, do you really think that kids are going to be truthful about their age if they've got to go fetch their parent and have them give consent through a credit card purchase?
I think it's the same problem, right? I think we're creating hurdles, like you pointed out, that encourage kids to circumvent them, and that's a big part of the problem that we simply haven't solved.
I think also another challenge is going to be what does the content look like? So let's say you've got an app, and that app decides, you know what, we're going to continue to allow under 16-year-olds on our platform, but we're just going to have a more dumbed down experience, less data collection, fewer social activities. It reminds me of a story that I had back in 2013. I got a phone call, completely cold, out of the blue, from Evan Spiegel, the founder of Snapchat. I don't know how he found out about me. One of his advisors suggested he reach out to me. I guess he found out that I do COPPA work. He calls me up and he says, "Hey, Shai, this is Evan Spiegel from Snapchat." I said, "Hello, Evan Spiegel from Snapchat. How are you?" Now, this was at a time where they were just starting out, so they were about 60 million users or so compared to what they are today. And the question he posed to me is, I don't understand, why is the under 13 demographic such a big deal? Why can't I just get consent via a credit card purchase, a small transaction, and even credit it back? So I said to him, well, yeah, you can certainly do that. It's one of the acceptable ways of processing consent under COPPA. But I said to him, well, but at the same time, I don't think you're going to have much conversion if you do that. And so he agreed, and he said, okay, you know what, we're going to work on it. Fast forward a few months, didn't speak to him again, maybe exchange a couple of emails, checking in. He launches something called Snap Kids. Does anyone remember what Snap Kids was? No? Okay, so point proven. Snap Kids was basically a dumbed down version of Snapchat. So what you would do is if you would say you were under 13 when signing up for a Snapchat account, they would veer you to Snap Kids, and all it was a way for you to take a picture and store it locally on your device. That was it. You couldn't share it with anyone, you couldn't send it anywhere, just store it locally on the device. A few weeks later, I got in touch with a new hire there, Micah, who was their chief policy officer, something like that. And I said to him, you know, I came across the Snap Kids product, and I said to him, I think what you're doing is far worse. Why? Because if now kids see what the alternative is, if they say that they're under 13, they see it's a watered down, useless app, that's going to encourage them even more to lie about their age. And so I wonder whether efforts by Microsoft and others to now expand the age is going to result in more protection for kids or actually less protection for kids.
I think it's a fair question. And I agree that kids don't want to use dumbed down versions of adult services. I think that's a complete dead end. And we've seen lots of the big social media companies try that. We've talked about Messenger for Kids, we talked about YouTube Kids, and yes, they're widely used, but for most kids, once they reach the age of, say, 5 or 6, they're not preschool anymore, they don't want to use an app that has the word kids in the name, and they certainly don't want to use a service that is a dumbed-down version of the adult service. So I think we need to change the paradigm of how publishers and content companies think about their audience and really focus on providing the same experience, but just treating the data more responsibly. It doesn't have to be all on or all off. There are lots of mixed audience games in the room that are equally enjoyable for adults and children that are exactly the same gameplay experience. It's just that the monetization is a little bit different. You're not plugging into profile-based advertising networks. You're taking contextual advertising, for example. And yes, there are some challenges around that, and maybe it is harder to monetize, but it can definitely be done. And the technologies and the services to support that are getting more and better. So I don't think we have to have this either-or approach to the market. We can treat kids' data responsibly and legally and still give them a great experience.
Well, I have my thoughts on that, but I think ideally under COPPA, and this is where COPPA and GDPR are very different in many respects. Under COPPA, if you get a parent's verified parental consent, you can go pretty much crazy. And you can offer all kinds of functionalities as long as you're only collecting that which you need to provide those functionalities. But you can offer all kinds of functionalities, pretty much collect any types of data as long as you have the parent's consent to it and you're using it for a valid business purpose. Under GDPR, that's not entirely true. Even with consent, doesn't mean you can just collect and use data however you please. There are additional restrictions around that. So there's a big difference there. But it really depends. The bottom line is that it's hard to get consent. Not only in terms of converting consent, but also in terms of verifying that you're dealing with a grown-up with the methods that we have available today. There's some new tech coming out, but even so, at the end of the day, the biggest competition to consent, whatever method you're using, whether it's credit card, social security number verification, signed consent form, maybe even some more sophisticated cutting-edge tech, the alternative is no consent at all, which is less friction, faster path to conversion. And if you need to minimize the data to do that, most companies will opt to do it that way. You agree?
I agree with that. Under GDPR, you can't really go crazy with data because the consent that you obtain, whether it's in the kids market or the adult market, has to be specific to a purpose, right? And so every time you want to use data for a different purpose or collect a different piece of data or share a piece of data with another provider, you have to get independent consent for that. And that just makes it completely impractical to do lots of things with kids' data. So in many ways, that really buttresses the data minimization principle under GDPR, which is that it forces you to really think about, well, do I absolutely need this piece of data? And forces you to minimize what you collect in order to provide your service. And I think that's, generally speaking, a really good thing. And I think for most kids publishers and apps, consent is not going to be a viable option, because unless you have the next world's most addictive game, like a Pokemon Go, say, it's really hard to get a kid to provide a parent's email, the parent to provide verification information, and to go through that whole funnel. It's just hard. So it may work for some really great kids' experiences, but for the average casual games publisher, for example, it's not going to be a viable option. So you have to figure out, how do I run my service without consent? And arguably, under GDPR, that's potentially easier than under COPPA, because provided that you can demonstrate that you have a legitimate interest in collecting the data that you need to provide the service, and that the collection of it does not negatively impact the user, you can probably operate on a legitimate interest legal basis. That certainly applies to contextual advertising, it certainly applies to analytics, it certainly applies to content personalization that's a benefit to the user. So we can probably do quite a lot under legitimate interest, but it's very important for us to think carefully about it and to document that.
And Max is referring to this cartoon right here, as a matter of fact, right? Balancing your legitimate business interest with the fundamental rights and expectations of the child. And making sure you've done that analysis before. It's called a legitimate business interest impact assessment, or LIA, something like that, if I'm not mistaken. Legitimate interest impact assessment, LIA. Okay, so yeah, you've got to do that analysis. But to Max's point, there's definitely some more flexibility under GDPR to leverage this legitimate business interest. Have folks here worked on GDPR within your organizations? Can you raise your hand or had some insight? Okay. Have you heard the term legitimate business interest quite a bit? Yes? No? Yes. Have you talked about consent at all? Okay. Good. Seems like legitimate business interest is winning the day. But like Max pointed out, consent can be challenging because it's got to be specific, it's got to be explicit, And also, you've got to be able to withdraw it as well, with as much ease as you gave consent. Okay, I'm going to skip over this because we're running out of time. Privacy policy tsunami of updates that we've been receiving. Necessary or not necessary, Max? What do you think?
You mean privacy policy tsunami or the GDPR consent emails that were being
the email updates.
Well, so the volley of newsletter emails that we've all received lately to basically say, yes, we want to stay in touch with this company that I don't even remember ever being in touch with. It seems like that was mostly unnecessary, apparently. And a lot of companies have apparently just shot themselves in the foot by essentially eliminating 90% of their email list. If you have a business relationship or a client relationship with somebody, then I'm told by lawyers, you did not need to reconsent to be able to communicate with them. If it's purely a marketing relationship, then I think the answer is yes, it was necessary.
Okay.
That's what I've understood from
marketing driven versus perhaps administrative alerts or even updates to parents about their kids' activities would likely not require new consent.
I think so,
necessarily.
yeah.
But
the privacy policies is another matter, and I do think privacy policies are incredibly important, both under COPPA and under GDPR, and it's something that companies very often neglect and only end up regretting once something goes wrong. I mean, going back to the civil lawsuits discussion we had earlier, one of the things that Disney and Viacom, for example, could have done to potentially prevent that lawsuit from being filed in the first place was to have specific privacy policies for those games that were complained about, where they explain exactly how and why those games are compliant, which I think they most likely were. But because they linked out to a generic privacy policy that applies to all Disney products, like many companies do because they're trying to be efficient, there was no room to explain why they were compliant, and it left this big gap of uncertainty in which the lawyers and the plaintiffs could formulate their theory of non-compliance. So, I think it is important, especially under GDPR, that we are extremely transparent and comprehensively disclose exactly how we approach compliance, how we decide the legal basis for data collection, what we do with the data, etc. That's going to be the number one level of protection that we can have against any enforcement risk.
What's interesting is that we've been getting a tsunami of email announcements about updates to privacy policy, but very few of them, particularly in the kid space, have been checking off this guidance from the ICO. So they're sending out the updates, but they're making their privacy policies actually more complex, when under GDPR goes a step further than COPPA. COPPA's privacy policy language has to be in a way that's understandable at least to parents. Under GDPR, it actually has to be understandable even to kids. Figure that one out. Especially if it's a kid that's of reading age, let's say between the ages of 8 to 12, maybe even 6 to 12. So
I think we're counting on you to help us with that, Shai.
Yeah, we will. We'll get there. We'll get there. So a quick story, and we've talked about enforcement, so we'll wrap with that. I did get an email this week, among many others like you, about a GDPR update. It came from a privacy tool company. So this is a company that is helping people maintain their privacy with some kind of unique tool. I got an email announcing their updates to the privacy policy. Sure enough, though, in the to line of the email subject, they copied and pasted everyone's email. Now, this is just a mistake 101. It happened years ago with a company called Eli Lilly, many years ago when privacy was, first started to be regulated. But what's remarkable is there's been this rush to just get out an update without thought and doing this methodically and avoiding mistakes like that. So how ironic. So then they had to send out another update about the breach and flood your inbox again. I am going to, since we're out of time, just share some closing thoughts with you about today's event. And then we will do our last raffle and then encourage people to stick around if they want to chat more or take off and make their rounds home. We started the day with Dylan Collins. He was supposed to come back, but I guess he got stuck in the meeting, but he appointed Max in his place. From Dylan, we learned that the kid tech space is big and it's growing. We learned that 100,000 new kids sign on to the internet a day, right? He left out a couple zeros there. We learned that Dylan knows how to wake up an audience at a conference as well, with some beat. Later on, we learned from Shai Samet that when designing app for kids, the human element is critical. We learned from Shuli and the Tinkerers panel that slime is still big and popular amongst kids, even older kids. And I can attest to that. I have 5 kids, and my 11-year-old is the biggest fan of slime. My wife can't stand it.
That's what makes it so good, right?
Yeah, yeah. She actually makes the slime herself with Tide, and she's got everything going with the whipped cream or whatever, the shaving cream.
Get a YouTube channel.
There you go, get a YouTube channel. Okay. We learned from Filippo of Pigsby that you can teach complex subjects to young children, even Bitcoin and blockchain. And you can even manage to find a way to transfer money cross-border with minimal fees. We learned from Eldad. Eldad, are you still here? He was here just a minute ago. That you can't say no to Shai. I don't know where you got that from, but apparently you can't say no to Shai, so I'm glad you didn't say no. We learned from Nicholas Walters of Hopster that when it comes to short form video content, the dog hasn't barked yet. It's still in its infancy. And we learned from Nick Gahn, who I believe was here just a few moments ago, that creating content for preschoolers is very expensive. But thanks to funds like the Shaw Rocket Fund, there's plenty of money out there. We learned from Leo, our friend from South America, that simplicity is the only non-obvious way of getting VC capital. And then finally, we learned from Dean Coughlin a new term, which I've never heard before, and I've been in the space for 19 years. Autonomity means autonomous devices talking to each other over a network. With that, thank you so much for coming. We hope you enjoyed the day, and we look forward to spending another Kid Tech conference with you in the near future. Thank you.